How would you feel if you have won a matter in the courts and subsequently the other party reopen the matter again and invite you before the court over that the same matter, over that the same subject matter which the court has decided originally? How would you feel? Would this be okay for you? Would you accept this? Would this serve as a justice to you, or would this serve as injustice to you? That is basically what we are going to consider today. In today's video, we are going to talk about the doctrine of res judicata. The doctrine of res judicata is something that every law student must know, especially if you are dealing with your legal system and legal method. You cannot joke with res judicata because it is the beginning principle for all law students. And in this video, we shall cover everything you have to know about res judicata. And not only that, you must know it, but you have to back yourself with authority, relevant authority, as far as res judicata is concerned. Because remember, he who has searched must prove. It's not just enough for you to say what res judicata is all about. You have to demonstrate the case principle that illustrates what res judicata is all about. And that is what we are going to do basically in this very video, as we uncover everything you have to know as a law student, as a beginner in the field of law, on what res judicata is all about, as well as the relevant case that could help you in order to make your A in legal system, in legal method. Hello guys, welcome to King's Advocate Network. This is where we basically discuss everything that concerns the law and the society. And in today's video, we are basically focusing on res judicata. We want to see what res judicata is all about. However, if this is your first time of joining this video and you have not had the opportunity to watch all my videos, because this is not just the first video. We started by introduction to legal method. From there we proceed to the divergent theories on law, as well as the meaning of law, as well as the functionality of law, and so many more. So I encourage you that after watching this video, you go and see to yourself the relevant videos that could be needful to you. Remember, journey as a law student is not easy. It's something you have to back yourself up, because then he said, God forbid that a lawyer should know all the law, but rather he should know where to find the law. I encourage you to check all those videos so that you'll be updated as we proceed to this lecture. And today basically we are talking about res judicata. What is res judicata? I want you to know that res judicata is a principle, is a doctrine, is a principle and a doctrine that has its origin from the common law. Res judicata is a Latin maxim, a Latin phrase that simply means already decided or already judged. That is to say, res judicata comes from the Latin meaning, which translates to mean that a matter has already been judged and decided. In a simplest term, it prevents the same party from relitigating a matter that has already been definitely settled by a competent court. Once a court has issued a final judgment, that is the end of that very matter. That same issue cannot be reopened again. Do you understand what we mean here? So we are trying to explain what res judicata is all about. And I'm trying to tell you that res judicata is a Latin phrase, is a Latin meaning, which translates to mean that the matter has already been decided. That is to say, whenever a court has decided a matter, if there is a matter between me and you, or you and I, and the court has decided that very matter, that party, you or I, cannot reopen that matter again. That matter has been fully decided and no party has the right under the law to relitigate or reopen that matter again. We are still going to consider the circumstances upon which this res judicata applies. But again, let us consider another thing you have to know. You have to understand that res judicata is a defense that operates in civil proceedings, where a matter has been fully tried and final decision has given by the court. If one of the parties tries to resuscitate or reopen it again for retrial, the other party will simply plead the defense of res judicata. That is to say, the case has been fully tried and determined by the court. The court will immediately discontinue that very trial. Res judicata is a principle, is a doctrine that basically applies to civil proceeding. Yes, it's criminal proceeding has its own matter. If you want to see what the criminal the principle that is opposite to this one, or principle that is related to this res judicata as concerns criminal proceeding, you go and check my video. Yes, check out my video on the playlist, the video that has to do with the meaning of ultra-first acquit and ultra-first convict. Go and check those videos. When you go to my playlist section, legal system and legal method, you are going to see meaning of ultra-first acquit, so that you can see res judicata opposite meaning as far as criminal proceeding is concerned. So basically, we are talking about res judicata in the field of what? Civil proceeding. Civil proceeding, res judicata here applies that if a matter has been decided by the court, a matter has been given final conclusion by the court, no party can reopen that matter. And if you try to reopen that matter, the other party can simply say, "My lord, this matter has been finally decided. This matter has finally been concluded. Therefore, spare me this double jeopardy." This is a principle of the law. There should be an end to litigation. That is what res judicata stands for. Res judicata stands for the fact that there has been a total trial of a case. There has been a total presentation of evidence and witnesses before the court, and for that the court has ruled on that particular matter. You cannot wake up tomorrow and stand again to reopen that matter again. But I'll still give you tips on how this thing applies, and you are going to understand it, so that you cross all your dots and also know your whereabouts as far as res judicata, legal system and legal method is concerned. We are going to proceed. The basic importance or the basic dividends of res judicata is that it is there to ensure that there should be an end to litigation. If there is no doctrine like res judicata, it means that the matter every day, parties will be before the court. There will be no end to litigation. That is what the principle of res judicata is all about. Res judicata simply means there was a matter between you. Let me use for instance, if there is a matter between you and your fellow students as regards to the ownership of a book, mind you, I'm saying instance, as regards to the ownership of a contract law textbook, you took your coursemate to this court. Then the court, after examining the evidence, say that actually it was that your coursemate that owned that contract law textbook, and therefore you should allow him to go with that contract law textbook because he owns the textbook. Do you understand? Now the court has decided that matter. Okay, you say, well, you then give up, or you gave up on that very matter after they have decided it. You didn't appeal. That I'm trying to explain to you now. Res judicata is relation to appealing of a case. You didn't do anything again. You just leave everything to God. Then tomorrow again, or next week, or thereabout, or next year, you wake up again and say, well, this textbook is still my textbook. I'm going to take you to the court again. If you go to the court, what the other party will do, for instance, if the other party's name is Stanley will say, "My lord, this matter has been finally decided. It might not be the same judge, yes. This matter has finally been decided, my lord. Spare me of this double jeopardy." I don't know what this guy is talking about. They have decided this matter on my favor, and the court has awarded me the free liberty to go with this book. Therefore, my lord, spare me this double jeopardy. Once that party has raised that thing, that is what we call in law as res judicata, meaning that the matter has been foreclosed, the matter has been decided. Therefore, no action should rise again. That is it. But that does not mean you cannot appeal a case. If a trial court has decided a matter, if a state court or a higher court has decided a matter, you can appeal within that reasonable period of time. Reasonable period of time means that you cannot just relax. There has been a matter, court decided a matter this year, you didn't appeal. Until next year, you wake up again and say, "I want to appeal." No. That is what statute bad. That's what we call in law as statute bad. That matter has been decided. There has been a statute of limitation. There are reasonable extent you can appeal in electoral matters. Basically, the constitution provided some days upon which you have to appeal your case. If you didn't appeal, Otilo, the matter is foreclosed and nobody will raise it again. So, all the issues in civil proceedings have statute of limitation. In criminal proceeding is the only area of law that doesn't have statute of limitation. That is to say, you can reopen criminal proceeding at any time because it is the state that prosecutes. And the purpose of criminal proceeding is to fight for the state. So because of that, the nature of criminal processes, it is not something that is limited. But civil proceeding, it has to go with time. If I slap you today, there are some reasonable time the court will anticipate that you should have instituted an action. And if you fail to do that, that means you have forgone your right. Remember, lex vigilantibus non dominantibus adurat, meaning that the Lord aid the vigilant, those who are awake, those who are alert to fight for their right, and not the dormant one. If your right has been violated, there are limitations, there are time you have to pursue that right. And if you fail to do so, that matter is forever foreclosed, either through statute bad, That is statute of limitation. You cannot reopen it again because the time has passed. That is it. But if the court has given a judgment, but you are not comfortable with it, you can still appeal. You can appeal to the court of appeal. If it started from the trial court, state high court, you can take it to the court of appeal. From the court of appeal, you can still go to the Supreme Court. But once the Supreme Court has decided it, you cannot go anywhere again until your next life you go to God and tell to God your matter. But no party again can reopen it. You cannot wake up tomorrow and start again with state high court and start again with high court or trial court or court of appeal. You cannot do that. That is what basically statute of limitation as well as res judicata stands for. Now, let us consider the circumstances or place upon which the res judicata will apply, because in law, in every general rule, there must be an exception. Let us see how res judicata applies. And before even going that, I want to give you some case. In case of Ito and Ebe, yes, before you speak, the case of Ito vs. Ebe is a case you must mention as far as res judicata is concerned if you are in Nigerian jurisdiction. That very case is a case that says that there must be an end to litigation. There must be an end to litigation, because if I allow everything that any party can institute an action at any time, everywhere will be filled up. There will be a multiplicity of action. That's why that case, the court established a principle that says that once the matter has been finally decided, no party can reopen that matter again. So when you talk about res judicata, you say that res judicata is a doctrine that stands for matter that have been already decided, and once the court has given a judgment on a particular matter, no party can reopen again. And this very assertion is giving judicial notice in the case of Ito vs. Ebe, or is giving judicial blessing in the case of Ito vs. Ebe, where the court stated the principle that once a matter has been finally decided, no party can reopen the matter again. This is how to answer a law question. You back it up with authority to make your A and to proceed to success. Mind me, success is very important. And now, let us consider the principles or the conditions. There are basically 4 conditions that res judicata must be applied. And these 4 conditions is not gotten from my head. Yes, this 4 condition is not gotten from my assertion. It is something that has been judicially given to us. Like I said to you, you are a law student and you don't talk on your head. You talk based on authorities. So what condition I'm going to give you now is something that has been taken judicial notice of. It's something that has been blessed by judicial authority, because I encourage you as a law student dealing with your cases, dealing with your studies, you must say everything proceeding from authority. The Apex Court, that is the Supreme Court of Nigeria, in the case of Makuno vs. Federal University of Technology, Mina, the citation is before you, you can check up that case, stated some principles that governs res judicata. The Apex Court gave a credence as to what condition that has to be in place before res judicata can apply. In that very case, now let us state the principle enunciated there. So the doctrine of res judicata, as said by the Apex Court in the case of Makuno and Federal University of Minna, was exposited in the following succinct word. It is a foregone conclusion, that is, I'm quoting the learned justice there, in law, that based on the doctrine of res judicata, where a court of competent jurisdiction has settled by a final decision the matter in the dispute between the parties, none of the party or his privates may litigate the matter again. The following conditions are notable in this very case I pointed out for the existence of res judicata, or for one to call, or for one to rely on defense of res judicata as regard to civil proceedings. The following conditions are noted. Number 1 is that the party must be the same in the earlier action as in the second action. Number 1 notable thing for res judicata to apply is that it must be the same party. It must be Stanley and Wagner. It must be Okeke and Taiwo. It must be the same party. There should not be variation to the same party. It must be those 2 parties. Now let us consider the second condition. The second condition is that the issue or the subject matter must be the same in the earlier action as in the second action. The subject matter must be the same. Everything, the subject matter refers to the main issue. The action, the what they are dragging in that case must be the same thing. The party must be the same thing. The subject matter must be the same thing for this res judicata to apply. Third condition given to us by this by the Apex Court in the case of Makuno vs. Federal University of Technology. Now let us consider it. The judgment or decision in the earlier action must be final one. The judgment and decision in the earlier matter must be final one. Yes, very important. Because sometimes the court can only give ruling but not judgment. There is difference between ruling and judgment, but that is not what I'm teaching you today. If you want to see more on something like this, subscribe to this channel, because we are going to have more of things like this. But we are focusing today on civil proceedings, and we are talking about res judicata. There is difference between ruling and judgment. If the court has given a ruling on a particular matter, in that very matter, that matter has not been decided. The court can rule on something. When you raise a preliminary objection, like if you are before the court and raise a preliminary objection over a particular matter, maybe to say that this party, this man does not have the right to maintain action, or this court that this action is brought is not the right court to bring the action. The man failed to institute the action in the right place. That is what objection is all about. If you have raised some of these objections, the court can rule on it. The court can either say yes, you don't have the right to bring an action. That does not mean that that is judgment. The court has not considered the merit of the case. They have only considered the technical error that surrounds the case. In this case, you cannot raise res judicata and say, well, my lord, the matter has been decided. No, the matter has not been decided anything, because the court has not looked into substantial evidence that surrounds that matter. The court has not considered it holistically. Therefore, nothing like res judicata in that very matter. 4. The court which adjudicate upon the earlier suit must possess the requisite jurisdiction over the suit. Jurisdiction is very important. It must possess the requisite jurisdiction over the suit. In case of Madukolo vs. Nkem Delemo, this very case talked about that jurisdiction is the life wire of every case. In fact, the jurisdiction is the blood of every case. What is jurisdiction? You will still encounter that in your second year if you are probably a year 1 student watching this video. Jurisdiction means the right the court have to hear this very particular matter. It's not any action. It's not just, you can't just wake up and go and institute an action. You must institute an action in a court with relevant jurisdiction. For instance, if somebody has taken your land, the right court to institute an action is not the Federal High Court. The right court to institute an action is the State High Court. Do you understand? If, for instance, the federal government, agencies of the federal government, it could be anything, EFCC, they threaten your life, and you are instituted an action against them for the court to restrict them not to disturb your life again. If you go to the State High Court, the other opposing party will bring a preliminary objection against you, because the court that has jurisdiction by virtue of section 251 of the 1999 Constitution to tackle that matter is not this State High Court but the Federal High Court. The jurisdictions between the government, the issue between the federal government and that of any other person is under the jurisdiction of the Federal High Court. I'm trying to tell you what we mean by here, that the court must have a relevant jurisdiction. That is to say that if you instituted an action against your classmates who have taken your textbook in the Federal High Court, this is a matter between you and your classmates. Federal High Court in this case have no jurisdiction. Do you understand? If you take your matter, or if you are taking your matter to Federal High Court, the other party, your classmate, could raise a preliminary objection to say that this court lacks the requisite jurisdiction. In other words, even if that court has given jurisdiction, even if that court has given judgment in your favor, that your classmate can challenge that decision, because the matter, even though it has been decided, the court that decided the matter lacks the jurisdiction. Because it lacks jurisdiction, the matter has not been decided. It is null and void. That's even this case I pointed in, case of Madukolo vs. Nkem Delemo. The court stated that no matter how beautiful a court might have considered its proceedings, once it is determined that the court lacked jurisdiction, that matter amounts to null and void. If a court has considered everything but it doesn't have the jurisdiction over that matter, imagine a Federal High Court deciding on something that has to do with land, or a State High Court deciding on something that has to do with mining. This is not within its jurisdiction. It's within the jurisdiction of what? Federal High Court. Or copyright, infringement, extradition. All these things are within the jurisdictions of the Federal High Court. And State High Court has no jurisdiction. We are not treating jurisdiction. I'm trying to tell you that these are the 4 conditions upon which res judicata must apply. 1, the matter has been finally decided. 2, the matter must be between the parties, between the same parties. It must have been the same person. Then 3, the subject matter must be the same. And then 4, the court must have a relevant jurisdiction to decide that matter. This is what res judicata is all about. And another very important case you have to know as far as res judicata is concerned for exam is case of Mahood vs. Hausawa. It's a case started in 2018 where the court also stated this very principle. The court copied that principle stated in the case of Mankun vs. Federal University of Technology, Mina. The court copied the same principle. That is to tell you that res judicata, now, the only thing I want you to take away from this is that res judicata is a Latin maxim that simply means already decided or already judged. Then that is to say, res judicata is also a doctrine, a principle that tries to say that whenever a matter has been decided, no party can raise that action against, both in this world and in the world next to come. That does not mean you cannot appeal the matter, but you can appeal within a reasonable period of time, because there is a statute of limitation in civil proceeding. If you didn't beat that statute of limitation, you cannot raise the matter again. That is to say, you have the right to appeal your case, but once the final court has decided that matter, the matter is forever closed. That is what you have to know about res judicata while dealing with your lecturer. But remember, your knowledge in this video is not complete. If you are definitely a beginner in the field of law, I have made a video that talks about 20 essential elements that all law students must know as regards to criminal law. I have also made a video that dealt with basic terms that are associated with civil proceedings. All these videos are in my playlist. All these videos are inside this channel. You can also watch this very video up now, the video that talks about ultra-voice acquit, ultra-voice convict, so that you compare it with this res judicata and see how it relates. Don't forget to subscribe to this video. Don't forget to subscribe to this video, because this channel is dedicated towards helping you to pass through your exams. This channel is dedicated towards helping you to navigate all the challenges you have, all the questions you have. You can always ask your question. If you find it difficult to understand what I said, ask me your question on the comment section, and also follow me on LinkedIn, all my social network accounts, Facebook, everything you see on that my description box. Go and check it, follow me up, and I'm going to answer your questions whenever I'm free. Just keep putting your question there. In the night, in the day, I will always answer your question. We help each other to grow. Please subscribe to this channel. Thank you, because I believe you have done that. However, click to watch this video. It's very important to your success.